What happens when the Corporate Transparency Act gets declared unconstitutional? Hi, I'm John Strohmeyer with Strohmeyer Law. Today we're going to be talking about a rushed update on what happens when a court in Alabama declares that the Corporate Transparency Act is unconstitutional. I'm not in my home studio, I'm out on the road, which is why we're shooting in a different location. But I wanted to make sure we got a quick update on this. So what has happened? Last Friday, March 1st, 2024, in the case of National Small Business United versus Yellen, which was pending in the Northern District of Alabama, a federal district court entered a final declaratory judgment concluding that the Corporate Transparency Act exceed Congress's constitutional limits on its own power and stopping, technically the legalese word is enjoining, the Department of the Treasury and FinCEN, the Financial Crimes Enforcement Network, from enforcing the Corporate Transparency Act against the plaintiffs. Now, FinCEN has already said they're going to comply with this and they will not be doing anything to enforce this judgment against the plaintiffs in this matter. So it's important to remember, if you get nothing else from this video right now, this doesn't mean Corporate Transparency Act is off the table for everybody. This is a single court case, and unless you are a plaintiff in that case, which means Isaac Winkles as the beneficial owner or applicant, the National Small Business Association and its members as of March 1st, 2024, those individuals and entities are not required to report beneficial ownership information to FinCEN at this time. That is the only judgment. If you are not one of those people or not a member of those groups, nothing has changed for you just yet. This is a case that only applies to those plaintiffs. What happens next? Well, who knows? I mean, you're here to hear some of what happens next. The next thing is FinCEN is almost certainly going to appeal this judgment to the 11th Circuit Court of Appeals, and there will be some decision. I don't know what that means or what will happen there. I will not pretend to know what's going to happen there. Whoever loses that case almost certainly will appeal it to the Supreme Court for their final ruling. Again, I don't know what's going to happen there. It's possible that it'll get overruled. It's possible it'll get upheld. There's just no telling. So for me and my clients in Texas, nothing's changed, and until we get a judgment from the Supreme Court or a judgment from the 5th Circuit Court of Appeals, where we are located, nothing has changed. And I'm going to keep telling clients to be ready to prepare for this. Two other things to think about, kind of as the top points. The ruling says that the Corporate Transparency Act is unconstitutional if it's applied as soon as the entity is formed because the entity hasn't engaged in any commerce. Okay, and then, I mean, the decision goes through a lot of analysis on the Commerce Clause and what Congress can do and what are the limits on their powers there, as well as the Necessary and Proper Clause of the Constitution and how they think that it didn't meet its burden there. I'm not going to go through it. I haven't had the time to go run down all those cases. I'm not going to get into whether or not the judgment is correct. But here's the thing, if it's unconstitutional just because you formed an entity, what I'd want to say is, well, what happens when that entity puts money in a bank account, if it buys something, if it runs payroll, uses a vehicle to transport goods, or just moves some wheat from one field to another? Well, they've engaged in commerce at that point. And so I think ultimately it's, all right, well, maybe the moment you form the entity, the case talks about how the moment you form something, you've really just done something with the state where you formed that, and you haven't really triggered anything. But once it started doing things, you're engaging in commerce at that point. And I think the line comes back. And so, point one, well, fine, forming the entity may not trigger anything. Maybe you get pushed back to whenever you've done commerce. So you've put an asset in this entity or you've done something. Who knows? We'll see what the further cases develop on this. But point two, the ruling also admits to the constitutionality of the updated customer due diligence requirements that apply to banks. And the Corporate Transparency Act, part of what it did was also require that customer due diligence rule be updated to be in line with the requirements of the CTA. And they talk about this in the case for a bit. This likely means that the banks are going to require some sort of proof that you, the entity, have complied with those obligations before opening or possibly even maintaining an account. Again, I don't work for a bank. I don't know what they're going to be doing as part of their customer due diligence reports, but those requirements, this case said that the banks are fully subject to those customer due diligence requirements, which say, they're going to be asking for that same sort of information. When they ask for that same sort of information, again, you're going to be telling the banks, 25% owners, substantial control, the sort of stuff that's required by the CTA and the customer due diligence rule. It's going to come back anyway. I would suspect that the banks are probably going to require some sort of, proof, your transaction receipt from filing your information with the CTA, with FinCEN, before they let you open a bank account. It's not a promise, but I guess that, while the entities may not need to file initially, once they're entering commerce, that's going to be enough of a hook for the courts of appeal or possibly SCOTUS to say, look, you're in commerce, it comes back in, maybe not initially on filing, but if you start doing stuff, if you start moving money around, that might be where it comes back in. But the banks certainly aren't going to say, well, we appreciate your position. We're going to disregard our obligations under our own regulatory regimes, and you don't have come on in. No, they're still going to require that information. It's possible that even if you don't have to have a constitutional obligation as the entity, the banks aren't going to open an account for your entity until they've seen proof of it. Again, this is speculation. Who knows what we're going to see? But thinking through this, it is a case that came out. It has made one decision for just about everybody, unless you're a plaintiff in that case. Nothing's changed. This ruling applies only to those plaintiffs. It is a potential of things to come, but until we have a judgment that applies to everyone, we, as an attorney, I don't have any other options but to say this law applies to you still. It's, if you want to start your own case in your own jurisdiction, go right ahead. I'm not a litigator. I don't know how to do that stuff. But ultimately, I see that CTA, one way or another, it seems like it's still kind of lined up to be enforced, if not explicitly, only because the banks are going to probably going to require, one, they're going to have that information to open the account to comply with their own regulations, and it's possible that they're just going to say, just give us your transaction report so that we know that it's been done. We shall see. A few questions that I've gotten so far about this. Well, why did they file it in Alabama? Part of being an attorney is helping clients achieve results. The National Small Business Association looked at their options. They could file anywhere in the U.S. They probably did some research, almost certainly did some research, and said, where are we going to find a judge who's going to be most receptive to our arguments? Clearly, they've got some options. And so they filed it in Alabama. I don't think there's anything magical about it being Alabama, other than they found a judge clearly who got the, I'm not trying to impugn the character of that judge. That's not the point. The judge was doing his job, made a ruling the way he saw it, and that puts those plaintiffs, National Small Business, on a better footing when they go to the Court of Appeal. That's not a promise. Look, courts of appeal will overrule things. So kind of thinking through, they had their options for all courts across the land. They picked Alabama thinking, look, we're going to take our chances in a court that's probably going to be more favorable to our point of view, and it seemed to work out. There's nothing wrong with that. Plaintiffs do that all the time. You get to pick a forum that is most opportune for you within the rules. This is what they did. I'm sure if they had thought it was going to be a better fit for them in Louisiana or Kansas or wherever, they would have filed it there. Let's see, what else did we get? I think that's probably it for now. This is something that's going to be developing. Again, the appeal to the 11th Circuit Court of Appeal, which covers Florida, Georgia, and Alabama, that's likely going to take a year. Beyond that, then you'll get something appealed to the Supreme Court, most likely, and who knows how long that could be. So it could be multiple years before the Supreme Court rules on this. So for the immediate future, nothing's changed. Unless you're one of those plaintiffs, the CTA is still in effect. You should still be replying and reporting as required until you have a judgment that covers you. For most of you listening, that's probably not you. So by the end of the year, if your entity was formed before 2024, you should get that initial report in. If you formed your entity in 2024, you've got 90 days from the date of formation to get that initial report in. If you have updates after you filed that initial report, then you've got 30 days to update FinCEN with those changes. We'll obviously be paying attention to this. We've got more content coming on Corporate Transparency Act because this is not the end. This is really, think of it as the first battle, the first shot in a much longer situation where it goes through the courts. And who knows, it may end up getting overruled and none of this goes into effect. We may get something that goes through Congress that makes the tweaks that judge said were deficient in the law that could then satisfy that judge. It's like, oh, well, he wanted these words and we found those words. We got enough people to get it through Congress. Who knows? For right now, though, get your reports in unless you're one of those plaintiffs.